Welcome everybody to today's webinar. Today we're talking about workers' rights in BC Part 2. We're joined by our amazing speakers, Jessica Foreman and Jim Wu, who I will be introducing in just a moment. Now, if you have questions about workers' rights in BC, you are absolutely in the right place. In today's webinar, we're going to be talking about your rights at work, as well as dealing with problems at work. What you can expect today, we have 60 minutes together, and we are providing answers to your questions. As I mentioned, we are basing today's webinar on questions that came in through part 1 of this 2-part webinar series. In part 1, we provided general and comprehensive information on a number of topics related to workers' rights in BC, and questions came in from our attendees during that session. And so we've taken the questions that were not answered and we've created an outline based on those questions. So that's what we're focusing on here today. What we will be providing is legal information, not legal advice. If what you're looking for is the law as it applies to your unique set of circumstances, then we encourage you to reach out to a lawyer. You're welcome to reach out to Forte Workplace Law. The contact information is on the screen. Of course, the information that we share today is current as of today's date. We, the People's Law School team, are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody who has joined us here today to reflect on where it is that they are joining us from. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes it possible for us to produce these webinars for you. And finally, we would love to welcome and thank our panelists, Jessica Foreman and Jim Wu. Jessica and Jim, as I mentioned, were here for the first installment of this webinar series. They are both lawyers at Forte Workplace Law. They're both excellent. The feedback we received from our previous webinar was amazing. They were described as top-notch, clear. The discussion was awesome and informative, and so we're delighted to have them back and delighted to have you here with us today to participate. So Jessica is a lawyer and workplace investigator. She practices exclusively in the areas of employment law and workplace and human rights. She helps employees and employers avoid workplace conflicts, solve their workplace problems, and proceed with court actions when required. She also speaks regularly about workplace issues like harassment and workplace safety and facilitates Forte Workplace Law's stand-up teams workshops. Welcome back, Jessica.
Thanks, Paula. It's great to be here.
So glad to have you here. Thank you. And we have Jim as well. Jim is also a lawyer at with Forte Workplace Law, and he practices exclusively in employment law. He loves going to court. He loves to give his clients a voice, and he does not back down from challenges. Prior to becoming a lawyer, Jim worked as an employment insurance adjudicator and made decisions on thousands of employment insurance claims. And that experience has been incredibly valuable in advising his clients about employment insurance matters and appeals and representing his clients at court and administrative tribunals. And we're thrilled to have Jim share his expertise with us here today. Thank you and welcome back, Jim.
Thanks, Paul. It's great to be back.
Wonderful. So we are going to dive into our questions. And the first question is for you, Jim, and it's about hours of work. So here we've got someone, my coworkers get to choose their schedules and work during the day, but my employer assigns me only night shifts and Sundays. Do I have the right to choose my schedule?
Right. So the key word here is concerning the word right. And as an employee, I see you have two sets of rights. You have guaranteed rights, and then you have negotiated rights. What is a guaranteed right? Well, for example, starting June 1st, 2024, every BC regulated job must pay their employees at least $17.40 an hour because that's the minimum wage, and that is your guaranteed right. What is a negotiated right? Well, that's anything that's above that minimum wage. That's for you and your employer to decide and to negotiate and to come to an agreement. Now, with respect to whether you get to choose your schedule, there is no guaranteed right for you to choose your schedule. However, you do have the right to negotiate for that right. What that means is your employer has a lot of valid reasons to say no, but there are some cases where your employer has to, at the very least, say, "Oh, let me look into that." And one such case is if you have religious obligations that occur on a weekend, then your employer does have what's called a duty to accommodate that request, but to the point of undue hardship. So let's just unpack what that means. It means that in the end, your employer doesn't actually need to give you the whole weekend off. They can simply ask, okay, what time is your commitment? Okay, in the morning, I see. So what if we have your shifts all start in the afternoon? That would satisfy the duty to accommodate. But even with this in mind, if you really want to work a different schedule, don't be afraid to ask your employer if you can have the right to choose your schedule and take steps to make it. The key is taking steps for your employer to say yes. And what you can do is you can talk to your other coworkers. For example, say if this organization, there are a total of 4 workers, you happen to be one of them, talk to the other 3, and let's say if they get all the weekends off in a month, just ask each one of them, can I get a weekend off of you? And then if they all say yes, then you're in equal standing as all of them.
Excellent. Great suggestions. And love the distinction between the, as you described, negotiated rights and the guaranteed rights. Another question, Jim, this one is about overtime pay. I'm a salaried employee with a billing target annually. I receive a bonus for any hours billed beyond my target at year end. Am I still entitled to overtime pay?
So this is taken exactly from the Employment Standards Act website. And it says if an employee is paid by a weekly, monthly, or yearly salary, overtime is payable to that employee. But the overtime kicks in not based on sort of your billings, but how much work you actually put in. So there's 2 ways which you can reach the overtime. One, there's a daily overtime, and then there's also a weekly overtime. The daily overtime is any hours you work above 8 hours is considered overtime. And there's a bit more of a breakdown. So any hours you work that's above 8 and less than 12 is paid at an hour and a half. So if you make $20, you get paid $30 for that period. But any hours, anytime you work past 12 hours a day is paid at double the rate. So again, using the $20 per hour, you work, let's say 13 hours. After you work the 12 hours, you get paid $40 an hour. And there's also a weekly overtime, which means if you work past 40 hours a week, then you're paid at an hour and a half. And an employee, what's important to note that is some employers, what they do is they tell an employee, okay, you're on salary, here's your agreement, it says that you're a salaried employee. Under the Employment Standards Act, and again, I'm reading this directly from the government website, it says an employee cannot agree, even with a signed contract, to have their salary cover all hours worked without being paid overtime, as this is contrary to the minimum requirements of the Employment Standards Act. Now, does that apply to all workers? It doesn't. So under the act, there are a number of jobs that are exempt from this rule. For example, neither Jessica nor I are paid overtime because as lawyers, we're exempt from the Employment Standards Act, but other professions such as managers, teachers, and if you work in the high-tech industry, you're also excluded from that as well, particular salesperson. So the best way to find out is to go to the Employment Standards website, see what sort of category you belong into. And if you don't belong to any of those categories, chances are you are entitled to the overtime.
Excellent. Thank you so much, Jim. This next question is also for you, also about overtime. My employer requires that I work overtime hours, but instead of paying time and a half for the extra hours, they insist that I take the same number of hours off from work another day, which doesn't account for the time and a half overtime pay. Is that legal?
Based on what I see here, the answer is no, it's not legal. An employer can only substitute time off in lieu of overtime by what's called an averaging agreement. And this averaging agreement is so tedious and meticulous and has to have so many requirements that must be met. And even if you miss one of those requirements, then that whole agreement can be considered invalid, and the employer will be required to pay overtime. So the act makes it very difficult for employers to not pay their workers overtime.
Beautiful. Thank you. And one last question for you, Jim, and then I'm turning over to Jessica. Okay, my employer says they can only pay me in cash under the table. What should I do?
So accepting cash is a valid form of payment. The act does say that paying Canadian currency constitutes as valid. Well, it's the only way. It's the only legal way of actually paying an employee, which is via Canadian currency. But what employers must do is they must also give their employees a pay statement. And that pay statement breaks down any deductions being made, such as CPP, EI, taxes, whatnot. It will also tell you how much vacation you have left, how many sick days are left. That is something they have to give to the employees. And if I could just give a cautionary warning to the employers, if you do not have these, you are putting yourself in significant risk, because whenever there's a dispute between concerning old wages, the first thing the branch will ask the employer is, where are your pay statements? And if the employer says, I don't have any, they will believe whatever the employee tells them to be the version of facts that they accept in the end. So make sure you issue your employees pay stubs and pay statements.
Excellent. Thank you so much, Jim. And we do have more questions for Jim. They're just going to come in a few more minutes. Thank you. Jessica, on the topic of leaves, our employee went from full-time to part-time for a period of 6 weeks while they recovered from surgery. What effect does a reduction in hours have on their 6% vacation accrual?
So this goes back to that comment Jim made about at the beginning about guaranteed rights, and the right to vacation pay is guaranteed regardless of the number of hours you're working. So it really has no direct effect. The Employment Standards Act says that once an employee has completed a year, they're entitled to 4% of all their wages for vacation pay. And after 5 years, they're entitled to 6% of all wages earned. Now, if an employee is working less hours and therefore earning less wages, that percentage of the amount being paid out is going to be less because the percentage is based on the total wages, but they're still entitled to be paid 6% vacation accrual if they've been there for 5 years, regardless of if they're working full-time or part-time.
Excellent. Thank you. Another question for you, Jessica. I've been a full-time employee for 2 years. I want to take a month off to visit my family overseas. My employer said I could take 2 weeks off vacation, plus all my accrued sick days, but no unpaid holidays. Are they allowed to do that?
And the short answer is probably. This goes back to that question, that idea that Jim mentioned of whether or not you have negotiated something in addition to what you're guaranteed. So under the Employment Standards Act, and I know Jim and I keep going back to that, but that's really the basis for all rights that workers have in British Columbia. So that's our starting point. Employees are entitled to, a certain number of vacation time off, depending on how long they've been employed. So this employee here is entitled under the Act to 2 weeks of vacation. Now, if they have a contract where they've negotiated for a full month or 4 weeks or 6 weeks of vacation, then they would be entitled to more. But if they haven't negotiated it, then the employer is allowed to say exactly what they've said here, that you'll need to use some sick days, but or unpaid time off or something like that. Just because an employee wants to visit family or has a very valid reason, they're not automatically entitled to that time off unless they've already negotiated it and have an employment contract that says that that's what they're entitled to.
Excellent. Thank you so much, Jessica. Another question for you on the topic of leaves. I was injured and can no longer do my job. My boss told me that they need me to be 100% recovered and cannot modify my workload. If I take a permanent medical leave, will I be entitled to severance?
So this is a pretty complicated question here that raises a number of legal issues. So I'm going to kind of walk through those. Jim mentioned earlier about this idea of the duty to accommodate. So that's coming into play here because when you have an employee who was injured, they, as the picture indicates here, this person's got some physical injuries, and those are considered a disability under the BC Human Rights Code. And an employer is required to accommodate anybody with a disability up to an undue hardship. So if this employee was working in a warehouse and by the picture can't use their arm and their leg and therefore can't lift anymore, an employer might be required to see if there's another kind of position for him in the workplace. Could they work at a cashier? Could they answer phones? Could they do paperwork? Is there another job so that they can continue to be employed? That's part of this duty to accommodate. But if an employee is ill enough or disabled enough that they simply can't work and they take a permanent medical leave, that does not equal severance. Okay. Severance is what is paid out by an employer when an employer decides to end the employment. And I know we talked about this a bit in the part one, but that's the idea of the notice that an employer has to give to an employee when they fire them or let them go. If an employee has a medical leave, they can apply for employment insurance under that, or they can just be using their company's short-term disability or long-term disability while they're off. The last legal issue, though, that comes into play here is if it's truly a permanent medical leave and the employee has a note from a doctor that says this employee will never be able to return to work. They're so disabled. That can constitute what we called a frustration of contract, which basically means the employment contract has come to an end. You're no longer bound by it, and the employer is not required to pay severance under those circumstances. So there's a lot of different steps and complicated legal issues that come into play in this one. So, but it's not an automatic that severance is paid out just because you're on a permanent medical leave.
Beautiful. Thank you so much for unpacking that question for us, Jessica. We are back to Jim for a question about benefits. If an employee works 20 hours per week, can they be excluded from benefits that the employer gives to employees who work 35 hours per week?
So in BC, benefits, they're not considered a guaranteed right. They are a negotiated right. So you would not be looking at the employment standard exactly. If you do have benefits, the very likely area you'll be looking at is either your policy handbook, or if there's a separate benefits manual, that's where it will be inside. Generally speaking, because this is a negotiated right, chances are you have already agreed to certain terms, including one where if you happen to work less than 35 hours a week, you may not be entitled to benefits. That being said, because this is a negotiated right, you have the right to what we lawyers call vary the agreement. In other words, negotiate for something else that's beneficial for your circumstances. Again, there's no key sort of there's no sort of one size fits all way of negotiating, but generally speaking, if you're reasonable and if you're reasonable, you're transparent, and you're personable, generally your employer is more likely to say yes than no.
Amazing. Thank you so much. And I just wanted to pause and acknowledge that these are really excellent questions. They come from our guests from the previous webinar, and I'm just really enjoying hearing the responses to these questions. So thank you, everybody, for submitting your questions. And thank you, Jim and Jessica. You're really tackling them very well. So thank you. This one is for you as well, Jim. I work in an organization where some managers allow employees to work from home while other managers do not. Is it legal for employees of the same organization to be treated differently under work from home policies?
So for work from home policies, generally the answer is yes. Working from home is considered a privilege. It's not considered a right. And the key difference is you can take away someone's privilege, but you cannot take away someone's right. And the privilege of working at home by that token can be taken away by the employer at their complete discretion. In some cases, the law will require the employer to give. Now, I'm actually just getting to the part where it says like if it's legal for employees of the same organizations to be treated differently from work from home policies. The answer to that is also yes, because going back to the issue concerning accommodations, the law does require the employer to give certain employees preference when it comes to working from home policies, especially if that employee has given the employer reasons pertaining to their psychological or physical well-being that requires them to actually be working at home. The law does require the employer to give those employees preference over those who do not have such conditions.
Excellent. Thank you so much, Jim. This next question is for you, Jessica. Here we have a situation where my manager is rude and condescending. There is no HR department. How do I report the behavior?
So whenever you experience behavior that you think is rude or condescending or bullying or harassing, the first thing to do as a worker is to go and to look at your company's policies. And every employer in British Columbia is required to have a respectful workplace policy or a bullying and harassment policy. That's a requirement from WorkSafe BC. So hopefully, even if it's a small company, they're still required to have it. And if you have that policy included in it, besides saying what's expected and what's not, should be something about a complaint procedure or what to do, where to go if you have a complaint. So if you don't have a policy or if that policy says go to your manager, you could ask, is there another manager you could go to? Is there a board of directors or a council or some other leadership? If the answer to all of those questions is no, then my advice would be to go to WorkSafe BC directly, because that is the body that oversees any situation where an employee or a worker is injured on the job. And an injury is broadly defined to include mental injury, which can be caused by bullying and harassment. So start with your policy, see if there's somebody else you can talk to. And if all else fails, call WorkSafe BC. There's a complaint form you can make to them, and they will open a file and investigate the situation.
Excellent. Thank you so much, Jessica. Another question for you, Jessica. Here we have a delicate situation. One of my employees has told me that they struggle with their mental health. They're also underperforming at work. When I raise concerns about their job performance, they turn the conversation back to their mental health. The current situation is not financially sustainable for my business. What is my duty to accommodate?
So this is interesting because the question comes to us from an employer side view as opposed to a worker. And as we talked about, this duty to accommodate is a two-way street, okay? Both an employer and a worker are required to participate in finding out that accommodation and finding one that works. So in this situation, I would say the first step is for the employer to try to get a better understanding of the limitations and the concerns that this employee is raising about their mental health. An employer is allowed, as part of the duty to accommodate, to ask an employee to go to their doctor and to get more medical information that can be provided to the employer. Jim and I regularly advise employers on this, and sometimes we'll even help them draft like a survey or a questionnaire that they give to their employee to take to their doctor. And that the goal of that is not to disclose and dig around at someone's private medical information. The goal is really to say to the medical professional, here's what this employee needs to do at work. They're required to focus for this many hours and complete these tasks and sit at a desk or work in a team or whatever. Are there any medical limitations to them doing that? And if so, what are they? And that will then come back to the employer and give them a much more concrete list of ways to accommodate. But without that information, the employer is really, really limited in their ability to come up with a solution. So I would say the first step is to gather that information and limit it to what they only need to know. And then once they get it, to come up with some proposals, go back and forth with the employee and try to work together to come up with a duty to accommodate. I just want to comment on whether it's financially sustainable. You'll remember that Jim mentioned that the standard is an undue hardship, which is a pretty vague term. But what that means is that a company does may be required to spend some money to accommodate. They're not required to go bankrupt. So I sometimes give the example of if you have an employee who's got a really strong sensitivity to smell, you're not required to build them their own office with a filtration system that would cost hundreds of thousands of dollars. But you may be required to provide them with an office with a door so that they can close it. So that undue burden standard is a bit hard to fully understand, but each business is looked at separately, how small they are, how big they are, and what kind of resources they have in determining what is and isn't an undue hardship.
Excellent. Thank you so much, Jessica. Jim, we have a question here about disability. I have a disability that limits the amount of work that I can do in a day and a week. I want to re-enter the workforce on a part-time basis. Can you recommend how to apply for jobs when I know that I will need accommodations? I have a persons with disabilities designation. Are prospective employers required to accommodate persons with disabilities?
So I'm going to answer by first sort of unpacking the phrase prospective employers, because they're very different from actual employers. And if we just go back to what Jessica said, the duty for prospective employers really they just have two choices: to either hire this person or to not hire this person. And when it comes to the idea of undue hardships, you can appreciate that an employer can basically provide a number of valid reasons why they would not hire this person, because it can be seen as an undue hardship. So how do you overcome that? By making this prospective employer your actual employer, because then when that happens, then the duty to accommodate becomes a lot more nuanced. The employer has to take steps, like Jessica just mentioned, to accommodate for the disability, such that the person with a disability is able to perform their job. And to that, in terms of this question, what I would advise is, well, we're not allowed to advise. What I would generally say is apply to every job as you would normally do so. There's no positive obligation on the employee to disclose to their employer that they have a disability, so keep that in mind. And likewise, employers are prohibited from asking questions about your disability. I should say prospective employers are prohibited from asking questions about your disability. So they cannot at the interview say, oh, do you have any mental or physical illnesses that we should be aware of? They're absolutely prohibited from doing that. And the best time to ask for accommodations is after you've accepted the job offer. Now, your employer might be pretty angry to learn that you have a disability. And if that's the case, I don't think you should be upset at all. You should be relieved, because if you told them beforehand, that employer would have probably not given you the job. So at least now you have a job that if they take any actions against you as a result of you disclosing that you have the disabilities, there will be remedies and legal options for you to pursue.
Excellent. Thank you so much, Jim. We have another question for you, Jim, which is regarding changes to your job. So in this case, the company I worked for was sold to a new owner. The new owner thinks I'm getting paid too much. Can they fire me or reduce my salary?
So the answers to both of those are yes. Let's start with the firing part. Employers are allowed to fire an employee without cause, and the obligation on them would be to provide that employee with reasonable notice. And what is reasonable notice? It consists of two elements. First, your minimum mandatory entitlement under the Employment Standards Act, which can range from nothing to a maximum of 8 weeks, depending on how long you've worked with the organization. And then there's, on top of that, an employee's right to common law reasonable notice, which is a lot more complicated. It looks at your age, how long you've been working with the organization, your position, and the likelihood of you finding a job similar to the one you just lost. But that can be that right, the common law right, can be limited depending on whether you signed an enforceable employment contract. So if you're ever when you're finding yourself in that situation, always go speak with a lawyer and see what your rights are. reducing your salary, believe it or not, they may have the right to do that because again, provided that they don't go lower than minimum wage, your salary isn't negotiated, right? So if they let's say if the employer goes there and says, I want you to sign this new agreement where you get all these perks, but in addition, in exchange, usually what they do is I'll give you a greater cut, I'll give you a greater cut of commission, but in exchange, your salary must go down. And if you sign that, then that is a valid, you have put yourself in an agreement where you have agreed to reduce your salary. But if, let's say, the employer does it without your consent, what we lawyers say unilaterally reduces your salary, then I think that question will be much more suited for Jessica to answer.
Okay, and Jessica, would you like to step in, or is that
Yes, well, it's because the next question
next
is
question?
asking this.
Okay,
exact question.
so
Thanks, Jim.
thank you. My employer cut my wage by 30%. They said that business is down and they can't afford to pay what they have been paying me. Is that legal?
So as Jim said, not without your consent. So if you consent and agree because there's some other perk or some other reason, it's fine. But unilaterally, and that legal word means, without consent or just doing it, imposing it on you, cutting your salary, demoting you, or changing a key term of your employment is what we call a constructive dismissal. And that's a situation where you can treat it as if you've been fired and are owed severance. And then the considerations that Jim mentioned about the common law or what you're entitled to come into play. So the key question, whenever there is a material change in your employment, whether your salary is being cut, you're being demoted, your hours are being significantly changed, the first thing is, did you agree to it? If you did, then that's fine. If you didn't, then it's that unilateral change. And if it's a material change to your employment contract, that's not allowed. And you may have a basis to claim severance. And I would certainly suggest talking to a lawyer to help walk you through that, because the concept of constructive dismissal is a bit of a tricky legal issue that requires you to do certain things immediately and take certain actions.
Excellent. Thank you so much, Jessica. This next question is also for you, Jessica. I work part-time at a daycare. My employer recently told me that I need to work full-time or I will be fired. Is that legal? What are my rights and where can I go for help?
So this depends again, because this can be considered one of those material changes to your employment. So it could, if you don't agree to it and it's being imposed on you, that could give rise to a constructive dismissal claim. If, for example, the reason that you can only work part-time or cannot work full-time is because you have obligations to care for family members, for example, that could raise the issue of human rights protection, which includes protection around what we call family status. So your employer, if they insist on it, could be breaching the human rights code and not accommodating you. So in terms of, what are your rights and what you should do, we always recommend that employees express your concerns in a reasonable, employees express your concerns with your employer reasonably, explain why you can't work full time, and maybe you can come up with some solution that works for everyone before you're getting fired or you're seeing a lawyer. But in terms of where to go for help, if the issue is related to a protected category under the BC Human Rights Code, you can certainly go to the tribunal. They've got a lot of great resources. They've got folks there who can help you, or you can talk to a lawyer. And, it's often the best advice is to try to get advice before you're at the point of getting fired, because a lawyer, excuse me, can help guide you in having those important conversations and protecting your job if that's ultimately what you want to do. The last thing I'll just say is there's, Access Pro Bono here in BC has a summary legal clinic where you can go for free summary advice. They provide 30 minutes of free advice. And the BC Human Rights Clinic also helps folks with human rights issues.
Excellent. Thank you so much, Jessica. Jim, here's a question about another potential change to the job. My employer gave me a relocation allowance under the condition that I work for 2 years. If I leave before 2 years, will I need to pay my employer back?
Right, so this sounds like it's negotiated right between you and the employer. The key here is whether all of this was put in writing. If it was in writing, then look at the written document to see if that is a condition, whether you have to actually work 2 years, or if you fail to do that, you may need to pay some of it back. And if so, how much of it are you required to pay back? Under the Employment Standards Act, a worker has a guaranteed right against having to pay for any of the employer's expenses that are basically deducted without the employee's consent. So the key here is to see whether this relocation allowance has been put into writing and what those terms are.
Excellent. Thank you, Jim. Another question for you, Jim, about applying for employment insurance. My company is shutting down and I've been given a severance package. When can I apply for employment insurance? When is my employer required to give me a record of employment, or ROE?
So as if I were back like 9 years ago when I was an EI adjudicator, my answer would be right away for both of those questions, but specifically, an employee should definitely apply within 28 days of their last day of work, and the employer has 12 days within the employee's last day of work to issue the ROE.
Excellent. Thank you. Jessica, here's a question about restrictive covenants. Can my employer restrict me from working within a 5-kilometer radius of their business for a few years after termination, or from opening my own business?
The answer is maybe, but probably not for what's listed here. And I'm going to go into a minute about restrictive covenants. That concept, those words, restrictive covenant, really what that is referring to is any attempt by your employer to restrict your ability to do certain things post-employment. So these apply when you are no longer working for that company. So we know that an employer can restrict certain things while you're working there. They can say you can't also work for a competitor. But what we're talking about here is what they can do once you've left, whether you've resigned, whether you've been fired, or however it is that your employment with them has ended. So the courts are pretty suspicious of these, and they don't like to enforce them. And the idea, of course, is that they want employees to be able to go out and continue to work and earn money, and not restrict that. There are some legal concepts that allow an employer to do this. And typically it's when the restriction is very, very narrowly tailored. So it's really limited by the length of time. Maybe it's a limit for only 3 months or 6 months, for example. A few years, in my view, would be too long and would be unenforceable. The other way they can be limited is by location. A 5-kilometer radius may be enforceable. Sometimes Jim and I see these clauses that say you cannot work in this industry anywhere in Canada. Okay, that's likely to be unenforceable. So the more narrow it is, the more limited it is, the more likely it is to be enforceable. The other consideration is, what kind of employee are we talking about? Are we talking about the CEO of a tech company who was very involved in developing some highly, protected AI? Okay, you can understand why, if they're leaving, a restrictive covenant saying you cannot go down the street and open that same thing to compete with us would be enforceable. Whereas a sales employee, who's just selling the product, by saying you can no longer sell anything in this particular area, that would be really, really limiting. So the general rule is that restrictive covenants are very, very hard to enforce. The narrower they are, the more likely they'll be enforceable. The broader they are, the more challenged or your ability you're going to have to challenge them. But these are tricky, and it's often something that I suggest you chatting with a lawyer about to help them kind of tease through whether or not it would or wouldn't be enforceable.
Excellent. Thank you so much, Jessica. Jim, this next question is for you. I want to make a complaint to the Employment Standards Branch, but I don't want to leave my job. I understand that a complaint can take over a year to process, and I'm worried that things get awkward at work. What should I do?
So a few things. Number one, you don't have to. You may remain in your job and still file a complaint to the Employment Standards Branch. Furthermore, the Employment Standards Branch actually has a number of um, options there to protect the employee. One is you can have your complaint be anonymized, meaning your information will not be disclosed to the employer. Now, if the business just happens to be you and your boss, that of course will not give you too much protections. But then there's another protection which they have, which is an anti-retaliatory clause within the Employment Standards Act that says if your employer fires you or basically does anything in retaliation against you filing a complaint to the Employment Standards Branch, then they could be subject to hefty fines and pretty crushing financial penalties. They also may be required to reinstate you, meaning that despite their protests, they will have to hire you back and give you full back pay as a possible remedy. So there are these protections. One thing I do want to comment, just sort of like in terms of when to file the complaint. Generally, the best time would be right away, especially if it's quite apparent that your employer is just not going to give you what you want. And this is especially very useful if the matter concerns unpaid wages. Let's say the matter concerns unpaid overtime wages. You've been working at an organization since January 2022, and your employer has paid you no overtime to date. And let's say today, which is May 14th, 2024, your employer fires you. If you file a complaint today, the furthest back you can claim for overtime would be May 14th, 2023, meaning all of the time you had from January would all be, you won't be able to get any of that. But let's say if you had filed a complaint back in January 2023, then what will happen is that complaint will basically get all of the overtime a year back, meaning you will have a claim for all of the overtime you worked since you started working. And that claim will then connect itself to the complaint you made after you've been fired, such that you're now able to claim overtime for the whole duration you work there. So that's for all it's worth, a bit of strategy in terms of how you can file complaints to the Employment Standards Branch.
Excellent. Thank you so much. We're going to now turn to some of the live questions that have come in from our guests. So I'm going to start with a question. My employer emphasizes the importance of perception. Even if you haven't done anything wrong, how your actions are perceived could lead to misunderstandings. What does the law say about perception? Is this something that you've encountered before?
No, it's an interesting question, and there's nothing in the law specifically about the concept of perception. You know, human rights law and WorkSafe BC, which governs issues of bullying and harassment, talks about expected behavior and things that we can and can't do. One area where I have seen this idea come up is that some people receive feedback or behavior and say that's bullying, whereas others view that as that's just performance management, or that's just me being a tough manager. So that may be what this question's getting at. What I can tell you is that the law uses a really, and I'm going to say unhelpful because it is unhelpful, standard called the reasonable personal standard. So when we are trying to examine whether or not something is bullying and harassment or is discrimination or is a breach, the courts use what's called the reasonable person in that particular situation. Now, of course, that doesn't really address the problem, because what if that particular person is very sensitive because of the trauma that they've experienced in their own life? And that's why they're feeling upset. So this idea of what the reasonable person is a really tough one that we struggle with a lot, especially in the human rights context. And I wish I had an easy answer, but I don't. I think it's something, if you're feeling that there is a miscommunication of expectations and you're perceiving things one way and your employer's, perceiving them another, talking about it can be one way to address it. And if you're still feeling like you're being treated unfairly because of that, then chatting with a lawyer who has some experience in human rights might be able to help look at this issue from that reasonable person perspective.
Excellent. Thank you so much, Jessica. Here's another question. I just signed a contract that says under two different termination clauses. So I gather there's two termination clauses. One, employer can terminate without cause in probation period and then terminate without cause after the termination. In the same contract, it says if I need to terminate, I have to give a minimum of 4 weeks notice. Is that fair?
So I can comment just very generally on that. The actual specifics, we're not allowed to give specific legal advice, but you are allowed to have specific termination clauses pertaining to the rights of the employee or the responsibilities of the employee. Say if they have to quit their jobs, they need to provide their employer with X amount of notice. There isn't actually a guaranteed there isn't a minimum amount of notice. You can just leave what you could technically leave without giving any notice, but there isn't really one that's specified. There's also some employers, what they do is they have a termination clause for what happens when you don't pass the probationary period. And then there's one for what happens if you're terminated without cause and what happens if you're terminated with cause. So having multiple termination clauses, it is something we do see pretty often in contracts.
Excellent. Thank you, Jim. Another question here, how long are employers allowed to retain discipline records, and can I request their removal?
So I don't know the answer of how long. Jim, do you know that answer?
Sure.
What'd you say? No?
I don't.
But I know I can talk about how to retrieve them. And I spoke about this a little bit in the first session, which is that under BC, there's privacy laws. There's a privacy commissioner that talks about what an employer can keep about your personal information, what they can do with it. And that's where you are entitled to make a request for those records. So if you're still in the company or you're still working there, you can certainly ask for copies of those. And if you're no longer working there and need them for some reason, you can make a request under PIPA. It's called the Privacy Information Protection Act. There's a timeline where they have to respond within a certain amount of time. The employer has an obligation to redact any information that relates to other employees, and there's a whole bunch of other requirements. So I would suggest that you go and look at the BC Privacy Commissioner website. That website also has a lot of really helpful tips and sort of cheat sheets, I like to call them, where they summarize the kinds of information that can be kept. Maybe it says something about the length of time there. So I would direct folks to take a look for more information to the Privacy Commissioner.
Excellent. Thank you. And we can provide a link to the Privacy Commissioner website as well with the recording that comes along with today's webinar. Here's another question. What can I do if I disagree with my manager's evaluation? I spoke with HR and they cannot do anything about it. This evaluation can make a huge difference in my pay.
You want to answer, Jim, or you want me to go ahead?
I can answer that. My general tip would just be do it in a way where just be mindful of what you can gain versus what you can lose. Because every time you disagree with something, there's always the chance of repercussions. The law is there to prevent any sort of retaliation, but the reality is employers do retaliate, and sometimes a disagreement with an evaluation can escalate to something far worse than just a reduction in your salary. Um, Unfortunately, I can't go into any more specific than that. Maybe Jessica, is there maybe something you would add?
No, I think that's great advice. I mean, if you feel really strongly, you've raised your concerns, sometimes I advise people put it in writing, send an email that just says, for the record, I disagree and here's why. It's on your file, you've made it, but I agree with Jim to tread carefully and that, there's not much else to be done there. And think about, like he said, what you're hoping to gain by that. Parties can disagree. And there's nothing illegal about that, as long as it's done respectfully. And like Jim said, there's no retaliation.
Excellent. Thank you. Um, Here's another question. What responsibility does my employer have if they ask me to cancel my vacation? And it sounds like here they've booked expensive travel, and it would be that versus working. The vacation is use it or lose it by year end, and there's no carryover to the following year.
So you do have a guaranteed right under the Employment Standards Act, which is that once an employer approves of your vacation, generally they can't take it away unless there's some very and to what I recall, there actually isn't any exceptions to that. The act is very clear that the employer actually has to give the employee the opportunity to take their vacation, and not only just take it, but take it in I believe weeks or certain chunks, such that we cannot mandate an employee to take, oh, can you just take 1 day of vacation instead of 1 week? But in that scenario, again, even though you have the guaranteed rights, the key is you need to be mindful that this is a place where you spend a third of your life. And so the key here is to communicate and maybe let the employer know, look, I just spent like $3,000 on this trip, and like the tickets are non-refundable. This will be financially disastrous if I can't go on this vacation. Is there anything I can do is there anything we can do to make it work?
Excellent. Thank you very much. Here's another question. I worked for a nonprofit for more than 15 years. If you indicate orally that that you would like to resign in a few months, does that count as notice, or should it not be written and signed to be official? If follow-up discussions are not documented, there are no emails or written communications, do they have much weight?
So I'll start, Jim, and I know you can jump in because you dealt with this issue, but there is law around resignation. And there's a lot, surprisingly, a lot of cases around whether or not someone actually did resign. So it's got to be clearly expressed, it's got to be unequivocal, and it's got to be accepted. So on the first piece, providing written notice is pretty clear and unequivocal. What's not considered a legal resignation is someone super frustrated and having a bad day, and in an outburst just shouts, "Forget it, I quit," and storms out. That may not be a resignation if the next day the employee says, "You know what, I had a rough day, I didn't mean it," or something like that. But the other piece is that it does have to be accepted. There has to be some acknowledgement of it. So it's a little unclear to me in this situation if that's happened, but that's legally what's required. Jim, I don't know if you want to add anything onto that.
Nothing too much other than just if the situation is such that one day you find out you don't have a job and you ask your boss, why do I not have a job? And they say, oh, didn't you say 9 months ago that today will be your last day? Make sure you, if that was not the case, that you tell the manager, I never said that. Or if you did say that, well, no, I changed my mind. I don't intend on quitting. I want to stay working.
Excellent. Here's another question. Do I have a legal right to leave early from the workplace to pick up my kid from school and continue my work from home? I can do my work from home, but my employer prefers that I be at the office.
Maybe I could start, and Jessica, if you want to add. So this goes back to sort of first of all, the ability to work at home is a privilege, which means your employer has a lot of discretion to say no to that. But in this case here, there is what I see a possibility of a family status argument to be made, that there's some accommodation issues that need to be made. But perhaps I'll let Jessica close that a little further.
And yeah, I mean, what the cases have said is it's not the regular day-to-day family requirements of picking up kids from school that qualify for an accommodation, but it's something more. Like you've got a child with special needs, and there's one specialist who lives 3 towns away, and that's the only time that you can get them their medical care, or you have an elderly person or something. So The law is really changing on this. We've had some recent decisions from the tribunal expanding the requirements for the employer. So, you know, I would say continue to be alive to it. But if it's just wanting to pick up your kid, the employer does have the right to say no, unless you have exceptional circumstances. You're the only provider, or there's nothing else that you can do. But as Jim and I keep coming back to, we're real advocates of encouraging folks to have these conversations and try and sort them out before you immediately go to what is my right, what am I required or obligated, because a lot of these solutions can be sorted out in the workplace.
Beautiful. Thank you. One last question, and then we'll wrap up our webinar. If an employer provides accommodation to an employee for remote work on the grounds of family status to care for a minor, e.g., grandchild, after the loss of a parent, can the employer then unilaterally rescind the accommodation, and when?
So I would say no. I mean, it is an ongoing duty that they are required to check in about. So if your requirements, if you no longer have to care for that child, then the accommodation would end. But as long as the disability or the protected class or the category exists, the accommodation needs to continue.
Excellent. Thank you so much. And thank you everybody for providing such excellent questions, both at our previous webinar and during today's webinar. I am going to turn to our guests. And Jim, I'll start with you. Just curious if there's anything else that you'd like to share with our guests based on what we talked about today, anything that comes to mind for you?
I usually just tell all my clients, regardless of whether they're employers or their employees, that your workplace is like another family. So the key here is not everything has to go into a dispute. Regular communications and just treating each other with respect can go a very long way.
Incredible. Thank you so much, Jim. And thank you again for all of your contributions to our webinars, both today and the webinar back in April. Jessica, how about you?
I obviously echo what Jim said, and there's a lot of great resources out there. We talked a lot about the branch and WorkSafe and all of these different tribunals. Each of those have information that is available to you. So, if you're having questions and you're struggling to sort things out and you don't want to talk to a lawyer, go to the People's Law School website, go to these other websites, phone them. They've got folks that are specifically there to help people who are unrepresented, and learn about your rights, learn about your options. The more empowered you are with information, the better you'll be able to help yourself.
Thank you again to all of our guests for joining us here today. Thank you, Jessica and Jim. We have loved having you back. Thank you for this two-part series. It's been so great, so helpful, so fun, and we will hope to see all of you again soon. Bye for now, and thank you.